I'm Christie Arkovich in Tampa, Florida, and we have a law firm that specializes in bankruptcy, student loans, other kinds of debt relief like mortgages and foreclosures and such. And I wanted to do a short video on what happens if you've been on the fence about filing bankruptcy or about doing something, and you don't really know what to do. The robbing Peter to pay Paul is happening, where you simply don't have the income to pay all of your monthly bills. Your credit is continuing to rise. I mean, in other words, what you owe is continuing to rise. Maybe your credit score is the same. Maybe it's even higher or lower, but you're maximizing your credit to where there's not a lot left at the end of the month, and there's not enough places to put it. We're starting to see higher interest rates cause a little bit less HELOCs being granted, constriction of credit out there where you're not getting the zero balance transfers that you were getting. We are seeing declines of credit cards where normally we would have had an easy approval for those folks. And so what that means is that if you're faced with problems, financial pressures right now, probably it's a good time for you to seek out bankruptcy counsel to at least see what your options are, to explore what the alternatives could be. And the reason I say that is because right now, around tax time, folks usually have some extra money to spend towards debt. If you don't think that that money, that tax refund, let's say it's $2,500, for instance, if you don't think that's going to cover what your debt is, then talk with a bankruptcy attorney, because you may find that you can do a Chapter 7 for that, and you're in and out in 90 days, and that debt is now gone, that unsecured debt. That might mean a signature type loan for consolidating credit, might be in credit cards and things like that. Bankruptcy also gives you the options to do some different things. You can do a loan mod that might have previously been denied, for instance. You can restructure a vehicle loan. There's just different things you can do in a Chapter 13. And so one of the big things right now that we can do is we can potentially discharge federal student loan debt. That was something that we haven't tried for a long, long time. For those of you who might not know, I used to actually work for Sallie Mae, ECMC, Terry, USA Funds back in the late 1990s and early 2000s. And I have to say, we usually won the case because it was very difficult for a debtor to discharge federal student loans. Now the tables have turned. The Department of Ed and the Secretary of Education are very, very much behind granting debt relief. And I don't know how long that environment is going to last. And so if you have any concerns, if you have a lot of federal student loan debt, you're worried that maybe the administration might change, maybe the rules might change under the current administration, who knows, if it's going to be some time before you get forgiveness, if you are even anticipating forgiveness at all. If you have a bankruptcy option to discharge your federal student loan debt now, why not take that? I mean, now the Department of Ed is more favorable than they've ever been. There was a judge that came out with an opinion here on April 5, I think last year. I just blogged about it. If you want to take a look at our blog, it's on Arkovich Law blog. And so, and you can find that, by the way, ChristieArkovich.com. And so this judge was pointing about how it's now time. And this has been a time that we haven't had before, and we're lucky to get it. And I think I would want to take advantage of that. And what I'm talking about is a new DOJ attestation process in an adversary. So you got to file the underlying bankruptcy, and then you pay extra for the adversary proceeding to discharge your federal student loan debt. Best case scenario, that debt's gone, and it's probably going to be a short period of time, less than 6 months, maybe even as little as 3 months. That's best case scenario, gone, totally gone, tax-free. Worst case scenario, maybe you do a settlement. If your income is such that you qualify for bankruptcy, you probably are going to have one of the presumptions that applies. And the presumptions are many. Over 65, maybe you've been in debt repayment on the student loans for 10 years. Maybe you didn't complete your degree, or the school closed. There's just a number of different things. Even disability is covered, where it's just a mere injury that impacts your earning potential. Okay, that's different than the requirement under a total and permanent disability, which is you cannot work. Here, we're good. I mean, just any kind of injury that impacts your earning potential. And to me, that means not the loss or inability to work a 40-hour job. That means maybe you can work 40 hours, but you can't work the overtime that you used to. You can't work the second job. You can't do the other things that allowed you to basically, pay those bills, pay those student loan bills. Those kinds of things are called presumptions. And yes, there are facts that the Department of Ed can come up with to oppose those, but the more boxes you can check, the more likely that you will be entitled to a discharge. And so that opportunity is now. The DOJ just passed, the DOJ procedures were just approved in November of last year. The first cases are rolling out right now for people who might have filed as early as January and such, or might have had a pending case and filed there. The other thing, on April 1, there were new means test rules, new tables that came out. And so basically for a family size of 1, if your income is below $60,429, then you are what's known as below the means test. Family of 2 is $74,131. Family of 3 is $83,000 and change. And finally, a family of 4 is just slightly over $100,000. So that means that if you make $100,000, if you're the sole provider of your household and you have a family of 4, you would likely qualify under the means test for bankruptcy filing. Now, there are expenses and things that are taken into account within a filing that you could, of course, qualify with an income that is even higher than that, or sometimes lower than that. It's based on what your overall expenses are. So you'd want to talk with an experienced bankruptcy attorney about how your situation would be addressed in a bankruptcy, whether it's a Chapter 7 or Chapter 13. We have a lot of materials on our website about the differences between them. The Chapter 7 is the shorter one, the Chapter 13 is the longer one. And but either chapter can be used to discharge federal student loan debt. So again, if you've got $2,500 laying around, you might want to think about doing some of this stuff now while the time is good, because we're afraid it might not be here forever. Things are changing rapidly, and we don't know what will happen with various appeals that are out there, various appeals that are threatened on things. And then like the elections, who knows what's going on there. So again, this is Christie Arkovich. Thank you for watching the video. Please subscribe. That allows us to continue to offer these. And if you want to reach out to us for any reason, we can be reached at info@christiearkovich.com or 813-258-2808. Hope you have a wonderful day. Thank you.